A criminal law university lecturer was sacked for raising questions, among other things, about referring to male sex offenders by their preferred female pronouns. That is just one aspect of free speech that is under attack in this country, and another is the recording of non-crime hate incidents, which I'll talk a little bit more about later in this video, because there's a very important development happening right now which you really need to be aware of. But first, this story is about Almut Gaddo, who for 10 years, or almost 10 years, taught at Open University, which makes this a little bit disappointing because I hold a first-class law degree from Open University, and I have to say that my experience there was very good, and almost everybody was very nice to work with, but I won't name and shame in this video. But Almut Gaddo was dismissed for questioning new requirements, which she says was to indoctrinate students in gender identity theory in ways that she felt distorted equality law and normalized exploitation. She says criminal law tutors were told to liberate the curriculum and that classes had to introduce diverse gender identities and teach students to use offenders' preferred pronouns. However, she raised the point that an assailant's language about himself and his offence should not automatically be adopted over the victims, and that lawyers and courts sometimes need to describe offenders in terms with which the latter may not agree, calling the innocent identifying perpetrator guilty or the trans-identifying male he. And whilst all this happened a couple of years ago, it is not over just yet, because there's a 4-week hearing scheduled for February and March next year, at which point all of these issues will be investigated by the Employment Tribunal. This case is being supported by Free Speech Union, raising money for it on Crowd Justice, which I'll link below. And as an aside, Free Speech Union is also bringing a case to rescue the Freedom of Speech Act. Perhaps more about that in another video. Now, if it wasn't clear by now, I support and promote free speech, as well as individual autonomy. That is the ability to make decisions and govern and control your own life without being coerced and pushed by anybody else, and without prying eyes looking over everything that you do. And for that reason, occasionally I partner with companies on my channel to help you do just that, one of whom is NordVPN. You may not know what a VPN is. It is a virtual private network. You might see this little bit at the top here that says my status is protected at the top right hand side of this window browser. If I was not connected to a VPN, it would say unprotected. This would tell me who my ISP is, my internet service provider, and my IP address, which can narrow down my location to within a very short area. So when browsing with a virtual private network, such as NordVPN, you get an anonymized IP address. They don't log or track what you do online. This has been independently audited a number of times now. And as you can see here, they're having a fantastic Black Friday exclusive deal. And if you use my code BBB, which is also linked in the description below, you'll get an extra 4 months free on this fantastic deal with a 30-day money-back guarantee. So what does a VPN do apart from keep you anonymous on the internet? Well, it allows you to browse securely with a top-level encryption on over 6,800 secure servers worldwide. It allows you to access a much wider range of content, such as films that are on streaming networks that are in other countries that you might not otherwise be able to access here. It comes along with a secure password manager, a secure private cloud to keep files in. It will scan websites and downloads for malware. It even allows you to connect your own devices together securely on MeshNet across your own private network. So once again, if you value your anonymity and secure browsing online, check out this fantastic deal with my code BBB linked in the description below with the 30-day money-back guarantee, and you won't regret it. But now on to non-crime hate incidents, which is a cause for concern because Yvette Cooper has suggested that these are going to be widened and expanded. Now, a non-crime hate incident is, as the name suggests, not a crime but an incident where somebody is caused concern, or merely where the person reporting it observes or perceives that something is motivated by hostility. Now, there is some updated guidance here, not that I necessarily agree with it all, but there is some guidance, and there's fears that this is going to be somewhat watered down. Now, the definition of a non-crime hate incident is also, in my humble view, a little bit too vague. This says that it is an incident or alleged incident which involves or is alleged to involve an act by a person which is perceived by another person other than the subject to be motivated wholly or partly by hostility or prejudice towards a person with a particular characteristic. Now, the particular characteristic bit, yes, I understand. Nobody should be deliberately being hostile and nasty towards somebody because of a particular characteristic. It's the first bit that I take issue with. It includes an alleged incident which is alleged to involve an act by a person which is perceived by anybody other than that subject to be motivated in this way. So if somebody rang the police and say that they perceived an alleged act by you to be motivated by hostility or prejudice, the police may then record that against you. Even though there's been no investigation, there is no evidence, there is no requirement for any evidence, but they will record that against you, and then that will pop up on an enhanced criminal record check. Now, let's say you teach children, you work in a school, or any other kind of scenario where you're required to have an enhanced criminal record check. This may well pop up, and they might say, well, we have a hate incident recorded against you, therefore we'd rather not give you the position. Now, an incident in this code here is defined in the National Standard for Incident Recording as a single distinct event or occurrence which disturbs an individual group's community quality of life or causes them concern. Now, a lot of people are concerned about a lot of things. A lot of people are concerned about what the government are doing, for example. But should that be recorded as a hate incident if it's motivated in a particular way just because it causes concern? Well, perhaps it should, perhaps it's not. I'm not here to tell you what to think. There are two sides to this argument, there always are, and this is an objective, balanced conversation. But this covers all crime and non-crime incidents. However, the threshold in and of itself is not sufficient to warrant a non-crime incident record being made. When an incident occurs, a non-crime incident is recorded on police systems as set out on this code. The code sets out other considerations that should be taken into account, etc., and then goes into particular characteristics, a person who is a person other than the subject, and so on. Now, the problem with all of this, again, in my view, is twofold. First of all, it is an interference with a subject's freedom of expression, which is, albeit a qualified right, it is a right under ECHR, under Article 10. You have the freedom to express yourself, even in robust ways, even if those ways offend and abuse other people, you have the right to do that. And that has indeed been upheld in court. Then secondly, if you have a non-crime hate incident recorded against you, this again may mean that personal data about you is being recorded when it really should not be the case. Now, there are, as you've seen on screen here, steps that should be taken by the recording authority before recording personal data. And it says as follows, which, depending on how you read it, it might work, and depending on who applies it and how they read it, it may not, with respect. But it says, if an incident which involves the perception of hostility or prejudice towards particular characteristics is reported to the police as perceived by a complainant or any other person, the recording authority should determine the following. Now, they first should determine that the event, remember, it's an alleged event. They don't need evidence that this actually happened. It just says that an alleged event reaches the incident threshold as set out in this code, i.e. it disturbs an individual, a group, or community's quality of life, or causes them concern. Now, for the most part of that, I don't take issue with, because if something was deliberate and it was malicious and aimed at a particular group, then obviously that is wrong. And if it disturbs an individual and a group and a community's quality of life because it is motivated by hostility and prejudice, obviously, again, that is wrong. But I don't agree with the last bit, which is causing them concern. Now, just causing somebody concern should not really be something recorded against you on the police databases, in my personal view. I don't often give you my personal view, but there it is. That's one of them. Next, they must determine that a criminal offence has not occurred. So whilst they are looking into recording something, they must determine that a criminal offence has not occurred, i.e. the criminal threshold has not been reached, meaning the incident should not be recorded as a crime, although they are going to record it against you as a hate incident. Contradiction in terms, perhaps. Thirdly, the perception of hostility is valid. So they just have to believe that somebody's perception is valid, which may well be true, but it may well be malicious, and how are they to know? That's addressed in the next point, which says there is no common sense reason not to record the incident. For example, that it's not irrational, trivial, or malicious, but that introduces a subjective element. What does the police officer assessing this situation think? And essentially that comes down to, do they believe the person that's saying, I perceive this to be a hostile thing, a hostile incident? If the police officer believes that, then they go ahead, tick that box, and ultimately they'll record a hate incident against you. which may be malicious. But I respectfully suggest that it'll be almost impossible for a police officer to determine that with any level of certainty just because somebody says so. Obviously, without any proper tribunal, such as a court, determining that fact, which is obviously not going to happen because this is not a crime by the very definition of it. It says, where only conditions A to D are fulfilled, it may be proportionate for the recording of authority to create a record without personal data. So they just record this happened, but no name against it, and it just happened. A bit like a crime statistic that they know that they'll never solve. And then it goes on, with regard to personal data, they may only record it with personal data if these conditions above are met and the below requirements are fulfilled. And those include any interference with the right to the freedom of expression is proportionate and necessary. So I repeat, any interference with the subject's right to the freedom of expression is proportionate and necessary. But that in and of itself, in the most extreme examples, would be clear. If somebody was deliberately malicious and prejudiced, stirring up hate towards an individual, we're getting towards the point where it would be a crime. And if it falls just short of that, then yes, you might want to record that against the individual. But how do you determine then at what point you cross that threshold? That would usually be for a court to determine, not an individual officer recording one of these things. Again, with all respect, it'll be this is putting an extremely difficult, and I make no criticism of the police here. What I'm saying is this puts the police in an extremely difficult position with a near impossible job to do, to record or not to record these incidents, which may then lead to other court cases. If they've recorded something against somebody and that person takes a grievance to that recording and takes the police to court, another waste of time, another waste of money, and ultimately the police may end up being found wrong by the court. Next, there needs to be a threshold test, which the incident presents as a real risk of significant harm. Again, we may be moving towards the criminal threshold again. G, a proportionate use of police resources is involved. That's something I'll come back to in just a moment in determining the identity of the individual. And then other elements throughout the code. Now, again, I come back to the time spent and whether it's proportionate, because a former commissioner of the Metropolitan Police has called for a review of non-crime hate incidents, commenting on a report that says 60,000 hours of officers' time every year distracts them from fighting crime, what you might call real crime, taking up police officers' time. This, of course, all following the investigation into Alison Pearson, which ultimately, to be blunt about it, in my personal view, of course, turns out to be a bit of a waste of time. Because again, in my view, the response was simply disproportionate and unnecessary. So do check out these links below. Support the Free Speech Union and these ongoing cases here and their ongoing case with the Freedom of Speech Act. You can read more about that on this page. I will link below. Please do like my video and subscribe to the channel. I'll give you time to do that now. I am aiming for 1 million subscribers. Be nice to get that by the end of the year, but let's see how quickly we can grow. And I can only grow with your help, watching my videos, sharing my videos, and subscribing down below. And so with that, I thank you for watching. I'll see you next time.